So start with a little self-surveillance. So I'm getting old and I have these new progressive glasses, and I'm gonna kind of look at you like this because I'm figuring out how to see. So thank you so much for having me here. And when I got invited to come, I was invited to talk about my research goals and directions, which was pretty broad. And what I ended up doing was writing a paper about method and the inter and multi and transdisciplinary interactions between law and surveillance studies, and also kind of about the ways that disciplines discipline. So personally, right, I didn't set out to become a surveillance studies scholar. I think people do now, but like I said, I'm getting old. So I was a legal academic writing about privacy law and intellectual property law, and looking for things that might help, with an undergraduate background in history and philosophy of science, which became STS, but again, I'm getting old, so it wasn't STS at the time. But I did know that there was a literature about technology studies, and so through that literature and reading some of the surveillance studies literature that privacy advocates in particular were reading, I found my way to surveillance studies as well. And I have to give a shout out to Canada generally, because Canadian legal scholars have always been in the vanguard of intersecting with surveillance studies, which is one of the things that makes them awesome. So as a result of all this, I find that I've developed a particular method of my own, which involves reading each tradition against the background of the other, increasingly critically, and I find that I've sort of become a weird kind of critical anthropologist of academic tribal discourse and behavior. And as I read this stuff and did this, I began to notice some things which led to the present paper. Really, I think in important ways, even as they have converged, legal scholarship and surveillance studies scholarship have been talking past each other. It's hard for many legal academics to really use the corpus of work in surveillance studies as a resource, because legal scholars are trained to resist the premise that surveillance is a mode of social ordering. Law is the source of social ordering. And surveillance is a subject of regulation. And surveillance studies academics, though, have the opposite problem. They often seem to treat law as monolithic, right? So law is the source of the assertion of the authority to surveil, and then you can critique that. But surveillance studies scholars often seem not to grapple with the ways in which legal processes are themselves cultural and social processes that shape surveillance discourses and practices as the contours of the authority to surveil are contested and produced. And because I consider myself kind of an STS person at heart, I use the metaphor of black boxing in the paper to describe it, and it's mutual. It's a mutual misrecognition that moves on both theoretical and temperamental levels. And so in the paper, I explore the mutual black boxing by considering works from both traditions on three topics: law enforcement, surveillance of movement in public space, commercial profiling, and social media surveillance. And I say in the paper, but I just want to stress this, the point was really not to take pot shots. I selected for citation only works that I like. But even so, then there are things to say about these problems, right? And so in each of these domains, legal scholars have things to learn, and surveillance studies scholars have things to learn too. So I talked about two sources of misunderstanding, theoretical and temperamental, and I want to start with the theoretical. Legal scholarship really mostly, although there are some exceptions to this, owes primary allegiance to liberal political theory, which treats the self as fundamentally independent from culture and fundamentally autonomous and rational and disembodied and all those good things. And so grand legal theory kind of tends to envision its mission as advancing the pursuit of traditional liberal freedoms, particularly freedom of speech and freedom of choice in marketplaces. And the freedoms are to be exercised by these disembodied liberal subjects. Work in surveillance studies is heterogeneous, but one can generalize about it, I think, to the extent that it tends to owe primary allegiance to other more critical traditions that are concerned with the social shaping of subjectivity and with the mutual constituting relationships between culture and structure and society and all of those good things. And so from that standpoint, it makes great sense to understand surveillance both as a mode of social ordering and as a means of shaping the subjectivity of surveilled populations, but then legal scholars are really resistant to that. And that makes it difficult to kind of take on board some of the really useful insights from surveillance studies about the effects and the harms of surveillance. So this is the easy part, right? Surveillance studies scholars can very easily see how legal scholarship about surveillance and privacy is the poorer for that. So one of the tasks that law traditionally has set itself is to articulate theories of harm for which it can then afford remedies. But if legal scholars resist understanding even very pervasive surveillance as producing social shaping and as shaping subjectivity, it's hard to explain what the harms of surveillance are. And so one of my favorite legal scholars is Neil Richards at Washington University in St. Louis, who has written about the perils of social reading and the harms of surveillance. And I, he knows I think this because I take him to task for it, but he's got this new paper out about the harms of surveillance, and he talks about blackmail and coercion, and the chilling effect. And that's not that's sort of a very traditional legal liberal taxonomy of harms, which sort of presume that social shaping is the exceptional condition. And in the rare occasions when you can identify it, then you can talk about coercion or blackmail. There's a miscommunication going on there. Another of the tasks that law sets for itself, and Lisa's great paper will talk more about this, is to restrain illegitimate excesses of power. But since the liberal legal tradition is so heavily reliant on the idea of a public-private distinction, it has a difficult time kind of recognizing and naming particularly private assertions of power. And this is a problem in the domains of commercial profiling and social media surveillance. I think I love to just come to these conferences and start riffing off of what other people have already said. So just as Kirsty talked about how business academia does not principally envision itself as critical, right? Legal academia has that going on too, right? The point of law is to help government work and to help society run. And if a bedrock presumption is that private ordering in the marketplace is legitimate, then it's kind of hard to turn around and look at that and identify pervasive dynamics of surveillance from which flow harms. And so there's this bizarre and wonderful and tortured and incredibly detailed debate about the behavioral economics of information privacy markets, and how do we know when we've given people notice and choice, and do people read privacy notices, and how do they behave? And people just go around and around and around and around because they aren't really able, particularly since they're drawing from economics, to come to grips with the idea of power as the social shaping of subjectivity. So legal scholars could do better, but critically, surveillance studies scholars could do a lot better too. And so for reasons I don't fully understand, and I said this already, that you read work in surveillance studies which talks about surveillance and as power, and power is law, and then we can go and talk about, what happens at borders or in organizations or wherever. But what I don't often see is a really careful probing into the ways that legal and regulatory actors understand and conduct and contest the shape of surveillance practices. So to put it differently, surveillance studies scholars don't seem to understand that legal processes are cultural processes, and this is a problem because legal processes are important in determining the shape of surveillance practices. Not all important, but important, and thus one should want, particularly if one takes the view that social ordering comes from discourses and practices, one should want to understand those discourses and practices as they are internal to legal cultures also. And so just to give a couple examples, it's really interesting to study, and this behavioral economic debate about notice and choice is an example of this. It's interesting to study the mobilization of liberal conceptions of consent within rulemaking processes. And there's this incredible wealth of primary evidence in rulemaking processes in the submissions from interested parties to regulatory agencies and the way that people talk about this. And I don't see a lot done with that, and I wish I saw more. Second example, which is riffing off Kirsty again, I love the idea of securitized information flows, but what I didn't see, and I think I didn't see it because your focus was on organizations, right, is there's this double meaning of securitization. It's a market concept as well as a national security concept, and as particularly in the global financial crisis, as it traced back to things like mortgage-backed securities, it relates to the relationship between information and risk management, and I don't see as often as I would like that connection to financial markets. I see statements about making individuals into commodities and the power of global capital, and that's really nice, but then I want to know, okay, so what are you talking about, right? What does that mean? And one way that you follow that through is to follow that through within the securitization of these financial products that are based, when you trace them back to their root, on individual profiles. Right, so that would be really interesting to see. Third example, which I do talk about in the paper, is the mobilization of discourses around innovation, which is such a critical part of the technoculture of Silicon Valley, and it's particularly in the U.S., but I think it's crept into Canadian and European data protection discourses as well. The idea that the data becomes a reservoir from which innovation can happen, and so that data protection regulation is a restriction on innovation is hugely, hugely important within regulatory discourse. And I don't see, and that intersects also with STS perspectives on the ways that innovation is conceptualized and structured, and I don't see as much done with that in the surveillance studies literature as I would want to see. And so now I get to talk about yesterday's Indian UID panel a little bit. But this just leapt out at me from that panel. So the first paper talked about the question whether the UID makes identity a commodity, transactional, right? Identity becomes transactional and a resource for global capitalism. And then the second presentation said it's not financial participation, it's health data. And to me, I saw that and I wanted to ask, okay, global capital for what purpose, health data for what purpose? The purpose, when you take into account the innovation discourse, seemed to me, and I don't want to assume this, but I would want to investigate it, seems so clearly to be bioprospecting. There's a very vibrant discourse within intellectual property policy about bioprospecting the natural resources of the developing world, and then it's kind of sucking them into the global north and getting patents on them, right, and making them into resources for global capitalism. So too with personal information, right? And to have, a population of passive colonial subjects as resources for bioprospecting in reservoirs of health data just seems to be what I would suspect to be so much of what this is about, that I would really want to push on that. And it explains so much as well about the reference that was made to apps, right? Apps for use of UID data and the involvement of the open source culture. This is becoming now, I think, positioned in a way as a playground for innovation, and it seems that it would be profitable to explore. So I've kind of digressed a little bit, and I probably have 5 minutes left at this point. Okay, so the theoretical mismatch between law and surveillance studies led me into this extended discussion of things that I think people from each perspective miss. And now I want to kind of talk about atmospherics a little bit. So one thing I wrote in my book, the Configuring the Network Self, about works in the critical tradition is that too many such works find power everywhere and hope nowhere, and seem to offer well-meaning policymakers little more than a prescription for despair. now I feel weird coming here and saying this because, and back to Kirsty again, right? I'm an in-between person too, right? So in a gathering of law scholars, I'm the quintessential dystopian theorist. But when I come to gatherings of other kinds of scholars, I want to pull my hair out and scream sometimes at all the power everywhere floating around and all the dystopia. And it's so important to do that, right? To identify power and to be critical, as David said. But then there's a next step that needs to be taken. And if one wants to make a difference, right? And the next step has to do with taking these insights and translating them into a form that can be made useful. And there are really two problems here. One is a problem of jargon. A lot of legal people I know won't read this stuff because they find the jargon impenetrable and unrewarding. And it's partly their own fault. And I don't want to dismiss that, right? There's a very snarky attitude, which David, you also talked about, coming back from law and policy, very dismissive sometimes of people who just analyze things. But I don't see a lot coming from the other direction either sometimes. And I think it's so important to have conscious efforts at translation that will make the insights of critique accessible, because if you don't make them accessible, they won't turn into anything. And it's particularly important, I think, to note here that although traditional journals may give incomprehensible and scandalous rejections, legal journals won't publish anything. And that can be useful to know, right? There are good and bad aspects to that, and you can sort of play those out for yourself. But there are some venues out there that you might wish to explore. And beyond jargon, then there's this temperamental issue, which I do talk about in the paper. Lawyers are pragmatists, right? Even theoretical dystopian lawyers, at the end of the day, want to know what will work. And power everywhere is great, right? But it's just not useful. There's a continuum, right? The totalitarian society is one point on it, but I don't think we're there yet. And it is useful to take sometimes a pragmatic approach towards identifying methods of sort of gaining regulatory traction on surveillance practices. And that's a way I think that surveillance studies, particularly in the critical tradition, can learn from law. What do I mean by that? I think there are three very concrete tasks that have to be undertaken in which critique could usefully be informed by law's pragmatic tradition. There need to be claims about harm. What are the harms of surveillance? There need to be claims about justice, right? Accepting the necessity of some surveillance, what are the structural conditions of a just information society? What would it look like? And then there need to be claims about operationalizing, it's a technocratic word, right? Reform proposals, ways to bring those structural conditions into being. The paper has a whole laundry list of legal scholars who I think are good to read on those points. I commend to you particularly works by Danielle Citron and by Val Steeves. And the, it's a tough balancing act to kind of seesaw back and forth between the critique and the productive / pragmatic sort of triangulation of solutions. But I do think that that is the ultimate game. Otherwise it's just a bunch of talk and a bunch of dead trees. And so I think that I think there's work to be done there. And I think that's probably it, right? I used my 20 minutes. Okay, so I'll just stop and thank you again. And I'm looking forward to hearing you.